Stern Electronics, Inc. v. Kaufman. Stern Electronics, Inc. v. Kaufman, 669 F. 852 Sir 1982, was a case decided by the U.S. Court of Appeals for the Second Circuit that ruled that a video game manufacturer, Stern Electronics, could copyright the images and sounds in a game, not just the underlying source code. The decision was one of the first to rule on the copyrightability of video games as an artistic work and one of a series of lawsuits in the early 1980s brought forth by video game manufacturers like Stern aimed at Background: in 1981, Stern Electronics, an arcade video game manufacturer, obtained an exclusive license from Konami Industry Company, a Japanese game developer, to distribute Konami's game Scramble in North and South America. The game is a side-scrolling shooter in which the player controls a jet aircraft and fires weapons at enemies, attempting to destroy as many as possible before running out of fuel or crashing into an obstacle. Stern began selling the game in the U.S. on March 17, 1981, and it quickly gained popularity, selling 10,000 units in its first 2 months on the U.S. market. In April 1981, the defendant Omni Video Games, Inc. began selling a knockoff game called Scramble 2 that bore substantial similarities to Konami's Scramble game. Procedural history: the case was initially brought to trial in the United States District Court for the Eastern District of New York. Stern Electronics, Inc. v. Kaufman, 523 F. Sup. 635 1981. The plaintiff, Stern, succeeded in showing probable success on the merits of its claim of copyright infringement, and the court ruled they were entitled to injunctive relief. Both parties claimed common law trademark rights to the Scramble mark and moved to enjoin the other from using it. Omni had ordered and sold a small number of headboards to be placed above the arcade game unit bearing the mark in the months prior to Stern's release of the game and, based upon that fact, made a first use in commerce claim. The court found that the defendant's first use of the mark was not in good faith and solely in anticipation of later imitating the audiovisual display of Stern's game once Omni had developed their own Scramble 2. Further, continued use of the mark by both parties could result in consumer confusion and economic harm to both parties to the lawsuit. Based on Stern's considerable investment in the development and marketing of the game and the large number of units already sold, the balance of hardships was determined to tip in Stern's favor, and Omni was preliminarily enjoined from use of the mark. Legal issues. Copyright issue. Anticipating that a unique, non-infringing code could be easily reverse-engineered to create a knock-off game that imitated the sounds and images of their game, in its appeal, Omni argued that Stern was entitled only to copyright protection of the underlying computer code of the game as a literary work, and that the certificate of registration granted valid copyright protection exists only in original works of authorship. Omni argued that the audiovisual aspects of the game were neither original nor fixed. They argued that the sequence of images displayed were created by the underlying computer program and were not the original work of the game developer. Further, because the sequence of images varies based on the actions of the player, they contended that each play of the game produced a new, original audiovisual work, not a fixed copy of the registered work. The court rejected these arguments, stating that sufficient elements of the look and feel of the game remain fixed regardless of the individual player's actions. The court also found that a moment of originality did occur in the creation of the specific images, spaceships, fuel tanks, and the look of the background terrain and sounds, missiles firing, explosions upon destroying enemy ships present in the game, and that the originality of these images was not completely dependent upon the underlying program, as many different trademark issue. Omni appealed the trademark ruling by arguing that they did indeed have superior common law rights to the mark due to their first use of the mark. Neither party held a registered trademark. Omni's prior use claim was based upon the fact they had ordered a very limited number of headboards bearing the mark in December 1980. Only 5 of those headboards found their way to the market prior to Stern's release of Scramble in March 1981, affixed to game units featuring other Omni video games. The appellate court agreed with the lower court's ruling that it was likely the defendants contrived this usage of the mark solely for trademark maintenance purposes in anticipation of plaintiffs' introduction of the Scramble video. The preliminary injunction was affirmed. Impact. Stern Electronics, Inc. v. Kaufman was one in a series of lawsuits that resulted from the increase in knockoff video games in the early 1980s. It is noted as one of the earliest and leading cases where the court found copyright infringement in a video game. It determined that video games may qualify for multiple types of copyright protection at the same time as audiovisual, graphical, and / or literary works, and would follow parallel developments in computer software with Apple Computer, Inc. v. Franklin Computer Corp. By 1988, the trend of copyright jurisprudence expanded from protecting entertainment software involving fanciful creatures and characters to allowing this protection to extend to the user interface of productivity. Software containing little or no artistic or creative originality. In the 1982 essay The Adaptation of Copyright Law to Video, Hamney summarizes the court's opinion that the audiovisual display is plainly original enough to be copyrightable, even though the underlying code exists independently and is itself eligible for copyright. Hamney also summarized the efforts of defendants. The 1997 book Ownership of Rights in Audiovisual Productions explains how this case establishes that video games are audiovisual works because they are fixed in the memory devices that can be displayed with the benefits of other technological components. The principle that video games are fixed audiovisual works would be affirmed in Atari v. Amusement World, as well as Williams Electronics v. Arctic. The principle would continue through the decision Midway Manufacturing Company v. Arctic International, Inc., after which the U.S. Copyright Office asked copyright registrants to decide whether to register the display as an audiovisual work and the computer program as a literary work, not both.